entrepreneurship is the only way jobs can be created, and the role of the government is to be a fair, strict, and unrelenting regulator and a proactive catalyst to entrepreneurs who run their businesses legally and ethically. Such entrepreneurship, I believe, is possible only under compassionate capitalism, which is all about capitalism in mind and socialism at heart. Our judiciary has a seminal role in fulfilling the dreams of our founding fathers. On our side, we, the leaders of compassionate capitalism, have to demonstrate our commitment to self-restraint in our compassion and perquisites, and in our commitment to good corporate governance, how equitable we are to share the fruits of the corporation with every employee, how we wield our powers, how we avoid vulgar display of wealth, and how simply we live. Having spoken about the commitment of the judiciary and the capitalists in building a great nation, let me come down from the sublime to the mundane and look at where we are in that march to our dreams of timely and affordable justice to the common man. The Delhi High Court delivered a judgment in October 2018 in a criminal case that took 31 years to resolve. 31 years after the Hashimpura massacre near Meerut in Uttar Pradesh, the Delhi High Court reversed a trial court acquittal order and sentenced to life imprisonment 16 personnel of the provincial armed constabulary who have since retired for their role in the killing of 38 Muslims. It said, and I quote them, "This case points to the systemic failure that results not infrequently in miscarriage of justice," unquote. These are the words of the Delhi High Court, not my words. Let us remember that the trial is still going on of the late Railway Minister Ellen Mishra's murder. It's now 43 years since he was killed in Samastipur in Bihar on 2nd January 1975. While the U.S. justice system investigated Bernie Madoff and sent him to prison for 150 years within 8 months of arrest, we have still not resolved the Satyam case after almost 10 years. Let me just look at the data on cases pending as on September 30th, 2018. There were about 27.9 million cases pending at the district level and lower courts on that particular day. Of these, about 70% of the cases are criminal and 30% are civil. Obviously, the rate of inflow is higher than the rate of outflow, else we would not have built up such a huge backlog. In other words, at the country level, we have 2% of the citizens filing a case or being accused of some criminal activity. It could be civil activity too. Of the pending cases, I believe that 60% of the cases are pending for more than 2 years, and 40% are pending for more than 5 years. I am told that 30% of the cases in the Supreme Court are pending for more than 5 years. There are over 2.2 million cases pending for more than a decade in lower courts. The largest number of pending cases is in Uttar Pradesh. UP has 25% of the total number of cases pending on an all-India basis, or about 6.8 million cases. I believe that 15% of the cases in Allahabad High Court are pending for more than 35 years. I am told that 48% of the total pending cases in courts pertain to the government, including public sector undertakings and autonomous bodies. I am told that the lawyers in the district court charge between 10,000 rupees and 25,000 rupees per case, and that the advocates in high court charge between 40,000 rupees and 60,000 rupees per case. I have also learned that in the Supreme Court, the senior advocates charge between rupees 5 lakh per appearance to rupees 20 lakhs per appearance. Please pardon me if I am wrong, because this is what I have heard from friends who are connected with these institutions, and therefore I am not certain that about the veracity of what I am saying. Assuming that the median income of an urban Indian is about 20,000 rupees per month, I am being liberal, and that the disposable and that of a rural Indian is about 5,000 rupees per month, and that the disposable income is low, obviously, the cost of litigation in India seems unaffordable for the common man. Further, going through the trauma of a court case is quite unnerving for any decent citizen. Being held as an under trial leads to loss of reputation in the community. Being held for long periods without trial means the poor accused is likely to lose his job. Why is this happening? I am a firm believer that the prosperity, security, and happiness of any nation is determined by its culture. What is culture? Culture is what brings us joy, what makes us sad, how we treat strangers, what we value in life, how we value and maintain our commons like rivers, parks, public spaces, and public properties, what makes us productive, how honest we are in interactions with others in the community and with our governments, how disciplined we are in following the rules of the community, how we put the interests of the society ahead of our own personal interests, what our work ethic is, how hard we work, how open-minded we are to learn from people better than us, and how open we are to admitting our mistakes and make effort to improve. Of course, these are among many, many, many attributes that define a culture. Therefore, our first requirement for making our legal system even better than what it is today is to look at our culture and bring about the cultural changes required to make our judicial system more productive, more effective, more meritocratic, more honest, and more citizen-focused, and of course to reduce the number of cases that come to the courts. Unless we inculcate these attributes in every young man and every young woman who enters our judicial system, and of course among the citizens of the country, we will not be able to achieve our lofty goals. What is the best instrument we have for this? I believe that leadership by example by senior professionals among both our lawyers and judges, and of course in the entire society, would be the best way to enthuse our young professionals entering this profession to embrace the culture that I spoke about. This is not an easy task and requires tremendous hard work, honesty, discipline, commitment, and sacrifice to lead by example, as Mahatma Gandhi did. Knowing the kind of senior professionals that are assembled here and that are by and large in the judiciary, I believe that this can indeed be achieved. The total number of judges in the country is estimated to be about 17,000. In other words, there is one judge for approximately 75,000 citizens. The Law Commission, I am told, has a target of one judge for every 20,000 citizens, or about 65,000 judges. This number is not increasing rapidly due to various delays in decisions by the central and the state governments. But what is strange is that as of December 31, 2017, as per court news, the Supreme Court had 25% vacancy. The High Courts had 40% vacancy. And the subordinate courts had a sanctioned strength of 22,704 with a vacancy of 5,676, or a vacancy rate of 25%. There could be two reasons for this. One, the non-availability of talent, and second, the apathy of decision-making to take timely decisions in recruiting. Therefore, there is an urgent need to increase the number of judges, of course, of the right culture that I spoke about earlier, particularly in our lower courts. However, it is important to remember that the productivity of judges is extremely important if we have to indeed use these increased number of judges for reducing the delays. Of course, we have to reduce the number of cases that come to courts too. Productivity is a function of many factors like culture, work ethic, education, and technology. Thanks to our colonial past, we in India seem to believe that higher your place in the hierarchy, less work you have to do. Let me illustrate this with an example. As I was waiting to be frisked by the security at an Indian airport a few years ago, I was quite intrigued by a scene I saw. There were 3 policemen at the frisking station. Of course, they must have been the Central Industrial Security Force. One did frisking. The second one stamped my boarding pass. Of course, this was No, even today they stamp the boarding card. Anyway. And the third was just sitting, what appeared to be idle. I asked the gentleman who stamped my boarding card whether he got bored just stamping throughout the day, that is 8 hours of his shift. He smiled and said with pride in his face, I quote him, "Sir, I have been promoted, therefore I do not do any frisking," unquote. I could not argue with that sound logic. I then asked the guy who was idle if he got bored just sitting idle throughout his work hours. He said, and I quote him, "Sir, I am the boss of these two. I am supervising their work," unquote. His reply obviously shut me up. Most of the people who have passed through immigration, either at arrival or at departure in Bangalore, even today, must have noticed that there is an officer to check if the immigration officer has indeed stamped your passport. This stems from our colonial days when there was a deep suspicion about Indians actually doing the work they were paid to do. But today, this cannot be the mindset of the government of Free India 71 years after independence. We must focus on work productivity in everything we do. We have to set our work productivity benchmarks after comparing ourselves with the best international standards and strive to achieve that. We must measure the work productivity of every person in judiciary. After all, you cannot improve what you do not measure. I do believe that just increasing the number of judges alone will not improve the situation. We have to modernize our archaic and vaguely drafted laws. Train our bureaucracy in drafting precise, concise, unambiguous, and easily understandable laws. Train our law students, court associates of judges, and entry-level judges better, and introduce rules to improve the work productivity in courts. Most of our archaic laws were drafted during the British rule with the aim of curbing the freedom of the ruled. Let me cite you a silly law that existed till a couple of decades ago, or probably till 15 years ago. No Indian could fly the national flag at his workplace or at his residence. There could not have been any sillier law than this. And it went on for almost 55 years. There could not have been... This happened because the British, understandably, did not want their Indian subjects to show any sign of solidarity against the British rule through such symbols. I can understand when the British were ruling. But for 55, 56 or whatever, 60 years after independence, to say that an Indian citizen cannot fly his own national flag in his office or at residence is the silliest law that I have seen anywhere else in the world. As a nation, we are unduly sensitive about our patriotism. In India, it is perfectly okay to be corrupt or to be dishonest. That's nothing that brings you down, because we see them in ample numbers day in and day out, wherever you go. But it is unforgivable if you did something that may be misinterpreted as disrespecting any national symbol. About 12 years ago, a case was filed against me that I had insulted our national anthem when the instrumental version was played at a function in my company. This went from the lowest court in Mysore to High Court and to Supreme Court for over 18 months until the case was dismissed in my favor. I ended up by spending 48 lakhs of rupees as lawyers' fees. There was a public interest litigation filed against Sachin Tendulkar several years ago, since he attended a dinner abroad where the tablecloth had bands of 3 colors resembling the tricolor. An overzealous citizen of Trivandrum filed a case against Mr. Shashi Tharoor MP, since Shashi held his right hand over his chest in the typical American way of showing respect to the national anthem when the Indian national anthem was being sung. There are many self-appointed moral vigilantes who file cases against actresses sporting dresses that these moral vigilantes consider unacceptable. Therefore, in many instances, cases are filed on the basis of opinions of rabble-rousers. Courts should stop admitting such cases. Second reason is our inability to draft laws unambiguously and in a simple language that it cannot be misunderstood and misinterpreted by both lawyers and judges in the lower courts. There are many reasons for this. One is that India is a large country with 15 languages recognized as official languages. I hope I'm right. It could be 14, 13, 15. Anyway, the meaning of a word in a language like English or Hindi used in framing the laws at the highest level in New Delhi may have different meanings in different contexts in one or the other official language. Second, the quality of spoken and written English is going down every day in the country, while the quality of Hindi spoken in the South has not been improving as envisaged by our founding fathers. The result is the preponderance of low-quality documents that are used by our legal professionals. I am telling you this all based on my own personal experience. This is not theory. My own experience with the central budget during the 90s is another good example. Every year, Devang Mehta, late Devang Mehta, and some of us at NASSCOM would spend almost 8 to 10 months with the bureaucracy in Delhi getting the language corrected to reflect what was intended by the bureaucracy and us. And then, by the time we were finished, the new budget would kick in. Many of the documents produced by our government agencies and courts have many spelling and grammatical mistakes and use long-winded sentences which are difficult to understand and could be misinterpreted. I didn't want to mention some specific documents, and I'm sure the honorable judges present here, honorable former judges present here would have noticed those documents. Let me give you another example of badly framed laws. The UPA government came out with the Foreign Currency Regulations Act, FCRA, to stem the flow of funds from certain countries aiding terrorists in J&K. Understandable. Absolutely no right-thinking citizen can object to that. Unfortunately, these FCRA laws have been framed so badly that even an Indian company born and registered in India but owned more than 50% by foreigners was considered to be a foreign company for the purpose of interpretation of this law, and therefore was brought under this law. Let's remember that as early as 1991, the government allowed 100% ownership in foreign companies in high-tech areas. It is 27 years since this happened. Further, a company like Infosys, born in India, registered in India, and founded by resident Indians like me, was allowed to list abroad and have 100% equity held by foreigners. This was approved in 1998 by the Finance Ministry. 2 years ago, Infosys received a notice from the government for contributing 2% of its profits, net profits, in Indian rupees from Bangalore to its own foundation in Bangalore under the corporate social responsibility rules set up by the NDA. This was while the UPA enunciated the law. Mr. Pranab Mukherjee, when he was the finance minister, I believe that it was at that time this law was enunciated for good reasons. It was NDA who sent a notice 2 years ago. All of this goof up happened simply because the bureaucracy just did not either have sufficient command of English or did not understand the purpose of the FCRA. The purpose of FCRA is to regulate inflow of funds from abroad and not the equity structure of an India-registered company. The third reason is the low quality of our judgments at lower level courts. Many retired legal luminaries who are my very close friends in Bangalore tell me that many judgments produced by lower level courts are vague, do not even refer to the section of the law according to which the decision is made, and are full of opinions. Such decisions at lower level courts are likely to result in a higher load on higher courts. Now, what is the solution? What is it that we, the common man, can do? The solution is to focus on many initiatives. First is that the lower level courts should not admit appeals filed in routine matters and based on opinions. Second, reappealing a case again at a higher court when an entity or a person has lost at a lower level court in a non-policy matter has to be discouraged. Alternative dispute resolution mechanisms like arbitration should be encouraged. The government should clearly define what types of cases could be filed at high courts and the Supreme Courts. Going to the Supreme Court accusing a person of insulting national flag or national anthem is not a wise use of country's precious but limited legal wisdom. I would say that only matters, constitutional matters, should go to Supreme Court. We have to provide better training for our law students in English, Hindi, and other official languages with a special focus on terminologies used in the legal profession in succinct, precise, and unambiguous communication, in logical reasoning, and perhaps give them some software tools to improve their productivity. There should be at least 2 courses in English or in Hindi, and the relevant state language, perhaps, every one of the 3 years at the undergraduate level for students wishing to pursue a law degree. For example, in the US, if you want to enter medicine after your basic degree, there is a course called pre-med. And they encourage you to take biology, genomics, and a few chemistry, a few courses relevant to becoming a doctor. Similarly, even in India, for those students who want to become lawyers, we should devise a suitable stream of courses. These courses should, of course, be continued during the law degree years with a focus on writing judgments in these languages using simple, unambiguous, and grammatically correct sentences, using precise and concise mathematical reasoning, and an additional focus on logical and mathematical reasoning and critical thinking. Before a person is allowed to enter the legal profession, there should be an intensive examination in English or Hindi legalese to certify the worthiness of the person to argue and write simple, unambiguous, precise, concise, and grammatically correct legal documents, with an additional examination on testing the ability of the person to use mathematical and logical reasoning and critical thinking in arguments. Those selected to become judges should go through an additional year of training in law and in writing and speaking simple, precise, concise, unambiguous, and grammatically correct English, Hindi, or perhaps other appropriate languages. In addition to the subjects involved in their duties, these candidates must go through a detailed course in logical reasoning. Many well-known judicial luminaries tell me that the students admitted to a law school should pass an examination like the one used for admission to the national law schools in Bangalore, Calcutta, Hyderabad, and other places, with a focus on logical reasoning, or LSAT as is used in the US. We can take the same stuff and perhaps judge the merit of the student based on their performance in LSAT. I am told that there is a huge shortage of good law teachers to start more law schools of quality in the country. I can understand that. I would suggest that the central government create about 500 scholarships every year for the next 25 or 50 years for bright Indian graduates in law to be sent to the UK and the US to do research in law and obtain a PhD degree. I know that the US system of law is different from ours. However, what we are looking for in these PhDs is 5 years of immersion in deep, independent thinking about a legal problem, ability to formulate ideas cogently and communicate them clearly, and to conduct classes like they do at Harvard or Yale or Oxford or Cambridge. I am sure many of you have seen the TV serial Paper Chase to appreciate how the US system focuses on interactivity, good pre-class preparation by the students, and focus on independent thinking by students in the classroom. It may be a good idea to send promising entry-level judges to courts in the US or UK to spend 3 to 6 months observing how the judges use technology and modern practices to provide speedy justice there. It may be a good idea to invite retired judges from the UK and the US as visiting professors to our law schools for a year or two to teach modern courtroom practices, logical reasoning, and precise, concise, and unambiguous communication. These initiatives will essentially make our law students and entry-level judges become logical thinkers, communicators, and users of modern technology and modern methods of managing court productivity. Now let me come to techniques. Since I am not a lawyer, I will not venture giving a layperson's observation on how the technical aspects of our legal system and the processes can be improved. I presume that office automation software like word processors, spreadsheets, presentation systems like PowerPoint and email systems would already be in place and extensively used even in the lowest level courts in India. I'm also happy that the Supreme Court has guided the creation of the Case Information System 3.0 and is being used even by the lowest level courts in India. I will speak about some of the modern technologies that have a place in achieving court productivity. NLP or natural language processing, audio and video conferencing, document imaging, digital certification and digital signatures, artificial intelligence, software robots or bots, machine learning, mathematical logic, expert systems, blockchain technology, workflow software, and many other areas of technology can serve as assistive technologies to improve productivity in our courts. NLP or natural language processing allows voice recognition, voice to text, and automatic translation facilities that should help in dictation of judges by our judges to be converted to word processor outputs, translating them to Hindi or English and other Indian official languages, and documenting witness statements, just to name a few of these applications. Such systems allow creation of databases for further research by our institutions of higher learning like national law schools, IITs, and IIITs, and IISc. Document imaging systems allow courts to convert human-generated documents into machine-readable forms to allow further handling of documents by computer software. Lots of research is going on in recognition of handwriting, such imaging systems to enhance productivity of codes and provide databases for further research using machine learning to improve courtroom productivity are very important. The Supreme Court, as I said before, has installed a good online e-court system or case information system or CIS 3.0 developed by the National Informatics Center, Pune. CIS 3 is a powerful system that provides both an online data entry and a query system for the cases that are registered in an Indian court. I am told that it provides almost all the information required by citizens, lawyers, judges, and court administrators. I hope this system uses a relational database in the third normal form, as we computer scientists say, and allows users to create logical views and SQL queries to obtain even more information than what is already provided by the designers. The CIS 3.0 system allows our national law schools and IITs to use the voluminous data generated by our legal system to develop bots and develop other tools of artificial intelligence, machine learning, and Bayesian analysis to assist judges in coming to judgments faster, obtain deeper insights into the problem of reducing delays in delivering justice, and in bringing fairness to the victims of our judicial system. According to the father of artificial intelligence, John McCarthy, artificial intelligence is the science and engineering of making intelligent machines, especially intelligent computer programs. I must admit that we are still far from success at the Turing test, which states that a machine is said to be as intelligent as a human being when a person interacting only through a terminal with two unseen entities, one of which is a computer and the other a human being, cannot distinguish between the human being and the computer based on the answers provided to him or her. Robots are becoming popular in the legal profession in the US. Baker Hostetler, a firm with 900 lawyers in the US, hired Ross, a robo-lawyer, to serve as a legal researcher in the bankruptcy law practice in 2016. Ross uses IBM Watson and machine learning technology to optimize its research methodologies. It is time that our national law schools and IITs too started working in these areas. Machine learning is about computer programs learning from large data and making decisions based on data. Machine learning helps in analyzing tax and employment laws. They're already being used in these areas. They predict how judges respond in certain situations. Courts and court departments in the US use machine learning algorithms to determine the risk of a decision regarding patent owner's track record, the deciding judge's track record, bail, providing bail, sentencing, and even parole. However, using such deep learning algorithms have a tendency to create biases, since the past data is generally full of biases against the poor and the disenfranchised within the country. issues that we have been trying to correct. This issue has to be kept in mind by Indian researchers, and a suitable solution should be designed to avoid such biases. Thomas Bayes is an English clergyman from the early 18th century. Bayesian thesis was that we can update our initial belief, also called prior probability, about a proposition with some new objective information to obtain a new and improved belief, what's called posterior probability. A good example of Bayesian inference is assessing the probability that I have cancer, given that my cancer test is positive, knowing the probability of cancer in the entire population, knowing the probability of obtaining a positive test for cancer in the population, and knowing the probability that the test comes out positive in the case of patients who indeed have cancer. Note that the first one is an important unknown, while the data for the other three can be obtained. Bayesian inference is a good tool in expert systems and machine learning. Let me now come to the problem of using logical reasoning in argumentation and in judgments. The first step is to teach 2 courses of mathematical logic as part of the law degree curriculum, making it compulsory for every student to obtain at least 80 marks out of 100 in each of these courses. Mathematical language, as you people know, some of you better than I do, is the most precise and concise form of communication of an idea. When you write a formula or a predicate, everybody who reads it understands it in exactly the same way as the person who wrote it. Thus, building a mathematical logic bent of mind right from the students' days helps our lawyers and judges to be concise and precise in their communication. The productivity of the court improves drastically. Basically, mathematical logic uses expressions or constructs like there exists X, or X implies Y, or if X, then Y, else Z, or Y if and only if X, to represent logical reasoning. Such a skill makes it easy to teach expert systems to students and perhaps assist lawyers and judges in their work. Whether our laws and our constitution can be represented in terms of mathematical logic is a task for our IITs, IIITs, IISc, and our national law schools to look at. I have not done that, therefore I may be wrong. Expert systems are tools that evolved as part of the initial years of research into artificial intelligence. An expert system is a computer software program that mimics the decision-making ability of a trained human expert in a given area based on rules, or also called, also on frames. I won't get into frames in this lecture. An expert system comes with a knowledge base which has to be built over a period of time from the judgments of well-qualified judges in this country. Building the knowledge base is perhaps the most time-consuming and perhaps the most difficult task Fortunately, the Supreme Court has done a good job in getting the Court Information System 3.0 ready, and I believe we can build a sound knowledge base using the cases that will accrue there. This knowledge base has to be built such that it is amenable to predicate logic, that is mathematical logic, solve complex reasoning problems using a knowledge base and an inference engine, which is an automated reasoning system and is built in the form of a set of rules, as I talked about earlier, in the form of if X, then Y, else Z. The result is logical reasoning. These expert systems involve both forward chaining and backward chaining. In forward chaining, an antecedent, that the left-hand side of the rule, fires a consequent, that is the right-hand side of the rule, and thus adds new information to the user. Backward chaining does the opposite. It starts with a set of goals or consequence or hypotheses and works backward to find the data that supports the consequent. I won't get into details here. The expert systems and chess playing programs were probably the first attempts at AI. They have been in existence since the 1970s. The best known expert system was Musings, which is a medical diagnosis system. A patient describes symptoms to Musings, and Musings suggests a diagnosis. I believe that expert systems will be a boon to teach logical reasoning to our law students and also to for the entry-level training of our judges. Expert systems will also play an assistive role in improving the productivity of judges in our courts. There is an opportunity for our law schools to contribute to training the law students and judges if they undertook projects to develop expert systems so that judges can be trained in legal reasoning and decision making as part of their training during the course, as well as law students can be trained. I would suggest another tool that the researchers in our law schools and IITs and IISc, IIITs, etc., can undertake to provide value to the Ministry of Law. When a new law is to be promulgated, it is important to check that this new law does not contradict or create what we in our area call referential integrity issues with any of the existing laws. Such work has already been done in developed countries like the UK as early as 1970s. Blockchain technology has the potential to be of much use in legal databases. Our national law schools, IIScs, IIITs, and IITs have to do research on the use of blockchain technology for courtroom applications. It is a trustworthy, peer-to-peer, encrypted, decentralized, and distributed ledger or database that is verified as true by vote by a large number of computers. Data from a transaction is stored in a file which is referred to as a block. It is basically a giant ledger that is time-stamped. That's very important. It is time-stamped. So no single person can defraud the system. These blocks form a chain, therefore it's called a blockchain. Some economists call blockchain system a global trust machine. It is because case histories stored in these blocks can only modify or deleted if at least 51%. You can set it to 75% or 76%, 95%. It's your decision. Only 51% of the computers involved in this blockchain agree to deletion or modification. A smart contract, which is basically a computer program, can be layered over such a blockchain or a distributed ledger to automate the execution of the terms of the contract without the need for a third-party intermediary. A simple example would be automatic interest payments on a loan. Imagine a contract involving multiple parties, multiple trigger points, and multiple milestones. It is difficult to imagine arbitration being better or faster than using blockchain in such a case. Of course, I am not very familiar with your domain, so pardon me if I am overstating the case. Workflow is the last tool that I want to talk about. It is a good software to be used in court for improving productivity. Such a software helps us to delineate the steps in any official process. It provides all the information needed to execute each step. It records when each step was entered and when it was exited. It records how long the case waited at each step and the reason for the delay. Workflow can also help some of these steps to be automated. The good thing about this software is that it helps us to set benchmarks for productivity for each official and then compares the performance of that individual with the target. The clients of the judicial system should be given full transparency to the workflow details of a case so that they know where their case is stuck and how long it has been stuck and the reason why it is stuck. It would be nice if the national law schools, IIC, IITs and IIITs investigate what kind of assistive role these technologies that I've spoken about and other technologies can indeed play in improving the productivity of our judges, particularly in lower courts. While I am a deep admirer of software tools and computerized information systems, I believe in the adage that any computerized system is as good as the people who use it. Let me recount an incident to buttress this statement of mine. Sometime in 1980, almost 38 years ago, one of my friends who had designed a computerized information system for a state government told me this story. I believe he was invited by a state government in 1974 January to design a computerized information system or CIS for managing the vehicles workshop of that particular state government. The system was to answer queries like, how much are we spending for the annual maintenance of each of our vehicles? What is the mean time between failures? What is the spare part that fails most often? And how are our maintenance engineers performing in maintaining our vehicles? My friend, who is a first-rate analyst, assembled a high-quality team, studied the requirements in detail, and produced a good computerized system to run on an ICL 1901 machine, which is a very old machine I don't think any youngster here would know about it. However, my friend was called in April 1976 by the PWD Secretary of the State with a complaint that the CIS, the computerized information system that my friend had designed, was not working, and that the PWD Secretary was very unhappy. My friend went to the state capitol and he was shown the various reports. According to the report, a particular machine maintained by unfortunately by the best engineer in the workshop was malfunctioning every fortnight, and a specific part costing about 2,000 rupees of the 1974-75 intake had to be replaced. The engineer was very upset with the computerized information system, since he knew that the machine was functioning well and that he had not been called to set the machine right at all. Therefore, he passed some derogatory remarks on all computerized systems and blamed it for bringing bad name to him. Rightly so, I don't blame him. My friend and his team went through and checked every line of the code for the system, used test data to validate its functioning, and realized that there was really no problem with the computerized information system. He decided to talk to the storekeeper to find out what was really happening at the ground level. He obtained permission from the PWD secretary to talk to the storekeeper or interrogate the storekeeper. He told the storekeeper that the computer had disclosed my friend the whole story, and that my friend would not disclose it to the storekeeper's bosses only if the storekeeper came out with the truth. The storekeeper's response was, "Sab, mai kya karu? PA Sab of the PWD minister wants me to send him rupees 2,000 when he asks. I asked one of the engineers. He showed me how to debit a spare part costing 2,000 rupees to a specific machine, sell the spare part in the market, get the money and send it to the PA. Isme mera kasoor kya hai?" That was exactly his reaction. My friend reconstructed the entire story after talking to various actors involved in this drama. As we know, Indian emergency was declared on 25th June 1975. Many of the youngsters were not born then. The Prime Minister wanted her ministers to demonstrate austerity in spending, and I am told that she decreed that no public function where a central minister was present should spend more than 50 rupees of 1974-75 intake. Today probably 1,000 rupees or something. But one of the cabinet ministers in the center did not believe in this austerity measure of the PM. He told his crony, who was the state PWD minister, to make arrangements for his comfortable stay whenever he made a trip to the state capital. The PA of the state PWD minister asked one of the pliant engineers to show the storekeeper how to debit a spare part costing rupees 2,000 to a specific machine. He asked the storekeeper, this engineer asked the storekeeper to sell the spare part in the market and give the money to the PA whenever the PA requested the storekeeper for money. The result was that the same spare part was debited to the same machine whenever the central minister went to his state capital. Unfortunately, The chosen machine was being maintained by the best engineer in the workshop. The computerized information system promptly showed that a certain spare part of a certain machine was failing often as a central minister went to his state capital. Unfortunately, the storekeeper was not a well-educated person. If Ranga or I were asked to do it, we would use what we call a normal distribution. That means this machine today, that machine tomorrow, this spare part today, that spare part today, all of them around 2,000 rupees. The moral of the story, my friends, is that any computerized system is as good as the honesty of the people who use it. Of course, there are many checks and balances that could be brought in today's more advanced machines. It is important to remember this story, since any information system will be a GIGO, that is garbage in and garbage out system, unless the people who use it are honest and use it for the right purpose, no matter how advanced the computerized system is. I can go on and on about technology assisting our judicial system to become better, faster, and less expensive. But as I said, culture and education are the basic issues which must be tackled first before technology make any difference to improving our judicial system. Thank you very much.